Hello, friends. I welcome you all to this session on law of evidence. Today, we are going to discuss the uh, provisions relating to confession in the Indian Evidence Act. What are the basic rules? What are the basic principles? What are things which are important to be kept in mind while taking confession? We will discuss all of that. So just have a brief overview of what we are going to discuss. First, we will discuss what is confession, and then there are two important aspects of it. That is when a confession is not relevant. That is when confession is not admissible, and then another will also discuss when the confession is relevant. So what are the cases, what are the circumstances when the confession becomes relevant, and then we will see an important aspect of it, that is confession of co-accused. What is the value of confession of co-accused? The sections today which we are going to discuss are from section 24 to section 30. Section 31 we have already discussed while we were discussing admission part of it, that is the evidentiary value of admission, in which it was stated that admission acts as estoppel. It is not a conclusive proof of the facts admitted. So let's start with confession. So confession, the meaning of the term confession. The term confession as such has not been defined in the Indian Evidence Act. It has not been defined anywhere. However, in a famous case, Pakala Narayan Swami versus Emperor, the term confession was defined by Lord Atkin. Remember, friends, these may be asked in the preliminary examination that who was the judge in Pakala Narayan Swami case who defined the term confession. So you should remember Lord Atkin. Now, what he said is that what is confession? Now, confession is a statement which admits in term of offense. That is, it is an admission which admits or which give reference with regard to offense. And what either it should admit that the person has committed the crime, or it should admit that he has, or at least he should admit that he has done all the substantial facts, all the elements that make up the offense. So confession is an admission. And what kind of admission it is? It is an admission in which either the person who is making it, he admits that he has committed the offense, or he at least admits that at any rate he has done all the facts, all the elements which constitute the offense. Now, just let us see that this confession, at times confessional statements are relevant, at times confessional statements are not relevant. Now, when the confessional statement is irrelevant, it is irrelevant, and that is provided in section 24, section 25, and section 26. So, at 3 points of time, as per Indian Evidence Act, confession has been made irrelevant. One, when confession is given under the uh, promise, inducement, or threat by a person in authority. So when confession is extracted by a person in authority by promise, inducement, or giving threat, then it becomes irrelevant. That is what section 24 states. What section 25 states, it's a very important section, has been asked many a times in examination, is very important from the point of view of practice for police officers as well as for judge, that confession made to a police officer is irrelevant. It cannot be admitted. And another is section 26, which says that confession made in police custody are also irrelevant. However, please remember, friends, that these are the basic laws, these are the basic principles, but all of these have exceptions. For section 24, we have got section 28, which says when a statement has been made by removing the element of promise, inducement, and threat, then it becomes relevant. For 25, we have got section 27, which says when a statement is made to a police officer and based on that statement some facts are discovered, then to the extent of the discovery, the statement is or the confession is relevant. Then for 26, there is an inbuilt exception that certainly for 26, 27 will also act as an exception to 26. And there is also an inbuilt that when the confession is made in police custody, it becomes relevant if it leads to discovery of a material fact. Then to the extent of the discovery of material fact, it is relevant. And another exception is mentioned within section 26 itself, which says that if the statement is made in presence of magistrate, though he is in police custody, it will be relevant. So that is what are the relevant aspects of confession and what are the irrelevant aspects of confession when made. Another thing which you have to remember is that admission is a superset of which confession is a subset. That is, admission, all the confessions are admissions, but all admissions are not confession. Only those admissions are confession in which an inference that the person has committed the offense or he has committed at least all the elements required for the offense will be, such type of admissions will be confession. Now let us one by one see section 24. So confession which is obtained by inducement, threat, or promise. So confession that has been obtained by inducement, threat, or promise becomes irrelevant, but there are certain conditions which are attached to it. First, the statement must be a confession. So it should be a confession. And that confession must have been made by an accused. So the person who is accused of the crime, he should have made the confession. Then this he should have made to a person in authority. Remember this, friend, this is very important, that what he is saying he should have had said to a person in authority, and this person in authority must have given him inducement, promise, or threat, the pit or tip, threat, inducement, and promise. So this element of threat, inducement, and promise should have come from a person in authority. Then it should be in reference, this promise of threat, inducement, this inducement, threat, or promise should be in reference to the case against him, in reference to the charge against him. And then it should also bring in his mind that by making this confession, he will gain any temporal advantage or he will be able to avoid any temporal evil. Remember, on all these conditions are satisfied, then only then the confession made to a person in authority becomes irrelevant. What should it be? That the statement should be a confession. Then it should have been made by the accused. It should have been made. It should have been made by obtaining or by giving inducement, threat, or promise. This inducement, threat, or promise should come from a person in authority. It should be in reference to the charge against him, and then it should, by giving this promise, inducement, and threat, the person making it should have a belief or a reasonable belief that he will be, by making the statement, be gaining any temporal advantage or will be avoiding any temporal evil. And all these conditions must coexist. Now, as I have told you, that one important thing is that the inducement must be in reference to the charge. It should not be inducement which is something which is not related to charge. Another thing is that it should be temporal in nature. So when we make a merely religious or moral inducement, then it will not be hit by section 24. So if we say by the name of God, or because of your it is your moral duty to tell truth, so these would not make it irrelevant under section 24. Then, person in authority. Who is a person in authority? This is a matter of great judicial discussion also. So, a person in authority is a person who, in reference to the charge, is able to wield some kind of influence over the accused. So, a person, he should be a person who should be in a position to wield some kind of influence, some kind of pressure over the accused, and that too in reference to the charge. So, that is what is section 24. That is, if a confession is made by giving promise, threat, or inducement by a person in authority with reference to the charge, then it is irrelevant. Now, section 25. What section 25 says is that confession to police officer is not to be proved. So, it says no confession made to a police officer shall be proved as against a person accused of any offense. The word used here is shall, that is, it's mandatory, it's not discretionary. The principle is that so that the police does not extend unnecessary pressure, or police do not extort confession out of the person who are accused. So this is something which is related to human rights as such. Now the important question here is, who is a police officer? So police officer is any person. He is not only that person who is in khaki uniform, but any person who is making investigation of a crime and who can file a charge against the accused person and have him prosecuted. So one who is conducting the investigation and one who is in a position to file charge against the accused is a police officer. Now, there are important things which have been asked under it, is that who all can be included in police officer. So in Abdul Rashid versus the state of Bihar, the Supreme Court said that excise officer, that is the excise officer under the provision of Bihar and Odisha Excise Act, was held to be a police officer, and therefore as excise officer was held to be police officer, therefore confession made to excise officer was held to be inadmissible. So confession made to excise officer is inadmissible because excise officer was taken to be a part of police officer. Now another is that confession made to custom officer, that has been held to be admissible because custom officers are not supposed to be the police officer. Similarly, confession made to railway protection force are also admissible because they are not held to be police officer. Confession made to NDP officer under NDPS Act, they are also admissible. Confession made to officer under FIRA, they are also admissible. So this is important, that police officer does not mean only those persons who are in khaki uniform or who are in the police stations, but any person who has the authority to make investigation and file charge sheet and have the person prosecuted is a police officer. Now, please remember that what would be the fate of a confessional FIR, that is, first information report. Now, in this, there was a famous case of Agnu Nagesha versus state. In this, it was held that confession made as even as a part of FIR, as they have been made before a police officer, would be inadmissible. But other parts, those parts which are non-confessional in nature, and if they are not hit by section 162, then they will be admissible as such. Now, so section 25 very clearly states confession made to police officers shall not be proved against the person who is making it. Now, section 26 is an extension of section 25, which says that confession made by accused while in police custody is not to be proved against him. Now, in the first case or in section 25, the person was making confession to the police officer himself. In this case, the person is making confession to some other person, not to the police officer, but in the custody of, while he is in custody of the police officer. So if he is in custody of police officer and he is making confession to some third person also, then that has also been made inadmissible in nature. And the reason being the same, that it is not admissible. Why it is not admissible? Because the principle is that the police may extort or use undue pressure to extort the confession. Now, one important exception to it, that confession which has been made in the immediate presence of magistrate will be admissible even if it is made in the police custody. Now, what is police custody? Does the police custody means that actually police is holding it or police is present there? No. There are two types of custody. One is actual physical custody and another is constructive custody. So in both of the time, whether he is in physical custody or whether he is in constructive custody, section 26 will apply and the confessions made will not be admissible. So custody has to be understood in context of police control. As long as accused is under control of police officer, he will be considered being in the police custody. Actual physical presence of police officer is not needed as long as accused is in effective police control. So, for example, there is an important example that a police officer arrests a person and proceeds to take him to police station. Now, on the way, he leaves the arrested person with some villagers and goes out for some work. In this case, police custody is maintained. So, please remember that in case, suppose a person has, police officer has arrested a person. Now, and he hands it over to the villagers and he goes for some personal work, then the confession which he makes to the villager, that would also not be inadmissible, that would also be inadmissible under section 26 because there is constructive police custody in this case. So confession made to fellow prisoners in jail is inadmissible because of constructive police custody. Confession made to doctor while police officer is standing outside is also inadmissible because of constructive police custody. Confession made to driver while police officer is not inside a car is also inadmissible because of constructive police custody. So section 26, that confession made in police custody is also not relevant, except when it is made in presence of magistrate. Now we will see, so we have seen what is confession, we have seen when confession is irrelevant. Now we will see the third aspect, that when confession is relevant. So now when confession is relevant? When confession is relevant when it is not made to a police officer, when it is made in police custody but in immediate presence of magistrate. That is itself an exception which is mentioned under section 26. It is relevant under section 27 when it leads to discovery. It is made to a police officer, it is made to person in police, it is made while the person is in police custody, and it leads to discovery of a fact connected with crime. That is what is section 27. That if the statement is made to a police officer, or when the statement is made when he is in police custody, and that leads to discovery of material fact, then to that extent it will be relevant. And fourth is under section 28 when the element of, which is an exception to section 24, that when the element of promise, inducement and threat is removed and then any confession is made, then that will also be relevant. So these are the conditions when the confession will be relevant. Now one by one we'll see. So section 27 says that when the information or statement has been given by the accused, based on that statement some material fact is discovered, then to the extent that the person or the accused person was in knowledge of that particular material fact, that statement is admissible. But remember, suppose a person says that after murder I have kept the spear, I have murdered A, and after murdering the knife with which I killed A, that knife I have kept in the almirah of my living room. Now, based on this statement, he makes this statement to the police officer. Now, as such, this statement is given to police officer under it is hit by section 25 and it will not be admissible. Now, based on this statement, the police goes to his living room, finds out the almirah, and in that almirah they find out the knife which is blood stained, and this fact. Now this fact will come under section 27 and this will now be admissible. What will be admissible? It will be admissible that the accused has the knowledge that where the uh, weapon or the thing with which the crime or knife with which the crime was committed, the accused has the knowledge of it. Now that part can be proved. But this part that he said two things, that I have murdered A and after killing A I have kept the knife here. So what can be proved by this is that he has the knowledge that where the knife or the weapon of the crime is. But this fact that he has killed A, this confession is still not admissible under section 27. Remember friends, this is very important to understand. Only to the extent that only that much information which relates distinctly to the facts discovered is admissible. So in Muhammad Inayatullah versus State of Maharashtra, it was held that if the Supreme Court held that it is essential to prove that the object was discovered from place of hiding. Now, in this case, what happened is that if person says that I have kept knife in the kitchen and that kitchen is an open kitchen and there are many knives in it, or I have kept the sphere in the playground. Now that is a place which is everyone, or it is an open place. Everyone has an access to it. So such type of statements will not be admissible under section 27. It should not be very obvious thing which will be apparent, which will be seen by everyone, which will be relevant under section 27. Only that which would require, for example, if there is some hidden aspect of it, something which is not usually known to everyone, then that aspect will only be relevant. So the court held it is essential to prove that the object was discovered from place of hiding. If the object is lying in open place and there are chances that others may know about it, it will be difficult to prove that object was discovered at the instance of information provided by the accused. Now, one very important case law which is asked in preliminary time and again is that of Devman Upadhyay versus State of UP. In this case, the constitutional validity of Section 27 was upheld. Section 27's constitutional validity was challenged because there is a right against self-incrimination provided under Article 20 of Constitution of India. And it was challenged that a person cannot be compelled to give evidence against himself. But Section 27 was upheld to be constitutional and in the case of Devman Upadhyay versus the state of Uttar Pradesh. In Muhammad Inayatullah versus the state of Maharashtra, it was stated that Section 27 is an exception to Section 24 to 26. That is, if even if a statement is obtained by promise, inducement, threat by a person in authority, and because of that statement some material fact is discovered, then it will be admissible as such. Under Section 25, if it is made to police custody and it leads to discovery, it is a police officer, and if it is leads to discovery, it is admissible. Same under 26, which is made under police custody. Now, that is what is Section 27. Now, let us see Section 28. As I have told you time and again that Section 28 is an exception to Section 24. That is, Section 24, if the element of promise, inducement and threat is removed, then the confession made to a person in authority will be admissible under Section 28. Now, one very important aspect is that is it important that the means by which the confession is obtained? Suppose that is a person promises to another that you tell me, I will not tell you, I will not tell anyone about it. Now, at that point of time, the confession is made by the accused. Will that confession be admissible? Will that be relevant? As we saw that under Section 23, admissions made in civil cases in which there is an express uh, meeting of mind between the parties or an express condition between the parties that admission of this fact will not be given in any court of law or this fact will not be used as an admission in any court of law, then Section 23 says that such fact will not be admitted by any court of law if there is an express understanding or an express contract between the parties. But under Section 29, that about confession it is not applicable. What Section 29 says is that even if a confession is obtained under secrecy, promise of secrecy, that I will not tell it to anyone, you tell me. Even if the confession is obtained in consequence of deception practiced, for example, if there is a person who is a coy uh, deployed by the police officer, then even then in that case confession is relevant. Even if the accused is drunk and he speaks something which is a confession, it will be relevant. Even if it is in answer to a question which he should not have had answered, then also if he makes confession, it will be relevant. Even if it is without warning to the accused. That warning is not given to the accused, that he is not bound to make that statement, and he makes that statement, and that statement is confessional in nature, yet the confession does not become irrelevant. So if the confession does not becomes irrelevant, if it is made, even if it is made on the promise of secrecy, in consequence of deception practiced, in consequence that the accused was drunk, or if the accused was answering to a question he should not have had answered, or if there is a want of warning to the accused that he is not bound to make the statement. Basically, it applies to extrajudicial confessions as such. Now, let us see another aspect of it, which is section 30, which is very important when crime is committed by more than one person. Now, what section 30 says is that when two or more persons are tried jointly, so please remember, they are tried jointly, and for the same offense, it's not that A is tried for some offense and B is tried for some other offense. Both A as well as B is tried for the same offense, and then the confession made by one of the accused will be relevant or can be proved, when proved, can be used against the other accused also. So when two or more persons, suppose A and B, are tried jointly for the same offense, then confession made by A is relevant against B also. Now, but it requires lot of prudence, and one very important case that has been asked time and again in preliminary examination also is that of Kashmira Singh versus State of MP. In this case, it was held that the confession can be proved, no doubt, under section 30, but there should be a rule of prudence. And what that rule of prudence is, that there should be some corroboration of the confession which is made by A to be proved against B. So some additional, it should not, it can be the sole, the conviction can be, but normally it is rule of prudence that some corroboration to the confessional statement must be obtained before convicting B, based on the statement of the co-accused. Now, another important thing is difference between admission and confession. As we have already said, that one of the difference between admission and confession is that admission is a superset, while confession is a subset of this. So all admissions are not confession, but all confessions are admissions. That is one important thing. Another is that admission made to a police officer would be relevant. Confession made to a police officer is not relevant. Admission made in police custody will be relevant, but confession made in police custody will not be relevant. Admissions which are made on the express provision that it will not be used in any court of law in civil case cannot be used. Confession when they are made on even in the promise of secrecy can be, uh, will be relevant. Another is that under section 31 we saw the effect of admission. Admission acts as a estoppel and it is not conclusive proof, while confession can be a conclusive proof. Now, one another important is, suppose there is an accused A and he has made some statement. Some of it is inculpatory in nature and some of it is exculpatory in nature. Inculpatory in nature means that he admits that he has done the crime, but some part of the crime, but at the same time he makes other statement which exonerates him from some other things of which he is accused of. So if a person is accused of two things, that is that he has stolen a property he is accused of being a stealing a property, and then he is also accused of that he has done cheating also in this process. Now, if he accepts that he has done cheating but he has not stolen that property, now can this both the thing that he has done cheating of some property and he has stolen some property, he is accused of this, that say property 1 he has stolen, property 2 he has obtained by cheating. Now he makes a statement of which some part he accepts that yes, he has done cheating as regard to P2, but he has not stolen P1. Now, can this, so this part that he has done cheating is inculpatory statement because he confesses that he has done something, and this part that he has not stolen the property is exculpatory part of his statement. Now, can both of them be taken together? Because in this he confesses to something and he also does not confesses to something. Is it possible? Is it, what should the court do? Should the court take the statement as a whole that and reject it? That it is not complete confession in itself, or should it take the inculpatory part and exclude the exculpatory part, or should it take the exculpatory part and remove the inculpatory part? Then answer to it was given in Nishikant Jha versus State of Bihar. In this, the Supreme Court said that court is free. It can rely on the exculpatory part or it can rely on the inculpatory part and exclude the other part, and it totally depends upon the satisfaction of court. The Supreme Court held that there is nothing wrong in relying on part of confessional statement and rejecting the rest. So, confessional statement at present, as per Nishikant Jha versus State of Bihar case, need not be taken as a whole. If the court is satisfied, it can take the part which it can rely upon and it can reject the part which it does not rely upon. Next is retracted confession. Retracted confession are those confession to which, suppose a person makes a confession at one point of time, but at the trial he refuses. He says that he had made confession. He says either he has not made the confession or he says that the confession was taken by undue influence on him or by putting undue pressure on him. Now, such type of statement which the accused or which the person resile upon later on is called retracted confession. Now, so when a person once having recorded a confession goes back from it at the stage of trial, stating either that he did not make the confession or made it under fear or misconception, then it is known as retracted confession. That is, he resiles from his statement. He does not says he does not accept that he has said it, or if he accepts it, he says that he has done it under some pressure. Now, what is the, should the court accept the retracted statement or not? Then in this case, it said that the retracted confession is still valid, but only thing which happens is that its evidentiary value, the evidentiary value of retracted statement or retracted confession is under question. Now, in Pyare Lal versus State of Rajasthan, the Supreme Court stated that conviction can be there even on the basis of the confession to which the accused retracts, provided the court is satisfied of its truthfulness. So the Supreme Court held that retracted confession may form the basis of conviction if the court is satisfied that it was true and voluntary made. So if the court is satisfied that it was the confession to which the accused has retracted from is actually true and was made voluntary, then the court can convict on that on the basis of retracted confession also. So if they ask that whether conviction is possible on the basis of retracted confession, then yes, conviction is possible, may form the basis of conviction, but the court should be satisfied that it was true and voluntary in nature. Now, however, the court said that prudence requires, the law of prudence or principle of prudence requires that when there is a retracted confession, before acting upon it, some corroboration should be necessary. So it is just like we saw under section 30 that when confession is made by a co-accused and Kashmira Singh's case, the Supreme Court said that before relying upon it, some corroboration should be sought. Now, there are two types of confession. One is judicial confession, another is extrajudicial confession. Judicial confessions are those confessions which are made for judicial magistrate in the court, while extrajudicial confessions are those which are made outside the court or which are not a part of the court proceedings. Now, are extrajudicial confession admissible in evidence? The court in Punjab, state of Punjab versus Gurdeep Singh case said that extrajudicial confession is admissible. That is, confession which is made outside the court, confession which are not a part of court proceedings, are also admissible. But the court has to see that whether it is reliable or not. If necessary, if the court is convinced about its truthfulness, that it is made voluntary, then even conviction can be based on extrajudicial confession. So that's all about confession, and let's have a brief review of what all we did. So we did that what is confession? A statement which by the accused where he admits that he has done the crime, or at least he admits that he has done all the things which constitute the crime. Now, when confession is irrelevant, it is irrelevant when it is made under the promise of inducement, under the by when it is given under inducement, threat, or promise, or when it is made to a police officer, or when it is made to a person in police custody, except in presence of magistrate. Section 24 states that if the confession is obtained by giving promise, threat, or inducement by a person in authority, and it creates an impression in the mind of the person who is giving the confession that by accepting it or by giving the confession, he will be able to avoid evil of evil nature or gain an advantage of temporal nature, then in that case it is irrelevant or it is not admissible. But merely religious or moral inducement will not vitiate the confession. Then person in authority means any person who has the power to wield and influence over the accused with reference to the matter in charge. Then confession under section 25, confession made to police officer are not to be proved. Police officer here means that a person who has power to make investigation and file charge sheet. Now, under section 26, confession made in police custody are not to be proved except when it is made in immediate presence of the magistrate. Custody here means not only physical custody but constructive custody also. So these are the cases when confession is irrelevant. Now, when confession are relevant under section 26 when it is made in police custody but in immediate presence of magistrate, Under section 27, when it is made to a police officer or person in police custody, a person by a person in police custody, but it leads to discovery of material facts. And then under section 28, that if confession is uh, obtained by removing the impression of inducement, threat, or promise, then also it is relevant. So, under section 27, what has to be remembered is that the information which relates distinctly to the facts discovered is admissible, but please remember it is admissible only to that extent and not anything more. And then in Devman Upadhyay versus State of UP, the constitutional validity of Section 27 was upheld. Then Section 28 is an exception to Section 24, that where the impression caused by inducement, threat, or promise is fully removed, the confession becomes relevant under Section 24 also. Then section 29, that if the confession is obtained by a promise of secrecy in consequence of deception practiced when the accused was drunk, or when he is answering to a question which he should not have had answered, or when it is for the when the warning is not given to the accused, that is not bound to make the statement, in those cases also confession is relevant. Confession under section 30, confession made by a co-accused who are being tried jointly for the same offense is relevant against the other also. However, in Kashmira Singh versus State of MP, the Supreme Court held that rule of prudence requires that some corroboration must be sought in that case. Then all admissions are all confessions are admissions, but all admissions are not confession. Admission is a superset of which confession is a subset. Then if confession consists of partly inculpatory and partly exculpatory part, then there is in Nishikant Jha versus State of Bihar, Supreme Court stated that there is nothing wrong. Court can rely on part of confessional statement and reject the rest. So partly confession can also be relied upon. Then in case of retracted confession, that is confession to which in a later stage the person making it retracts or reciles. The thing is that its evidentiary value is to be seen. The conviction can be based on retracted confession, but rule of prudence would require some corroboration to the retracted confession. Then there are two types of confession which are given in court proceedings or to judicial magistrate. They are judicial confession, and confession which are not made to the as a part of court proceeding or not given to a judicial magistrate, they are extrajudicial confession. Now conviction can be based on extrajudicial confession. Extrajudicial confession are also admissible, but it is for the court to see that it was the confession made is true and is voluntary in nature. Thank you so much, friends.